1 second, we get recorded here. Oh, there's Jeff. There's Jeff. Just get it picked up.
That might be speed.
Yeah, his mic is. Was that me or that was the computer in the back? All right. That's frightening. All right.
Recording live now? Okay. All right, well, this is the April 6th, 2022 meeting of the City of Charleston Board of Zoning Appeals Site Design. Present are Amanda Barton, Ravenel, Jeff Webb, Jennifer DeCientis, myself, Joel Adrian, present from the staff, Eric Schultz, and Lee Batchelder. These proceedings are being recorded. We ask that those who speak identify themselves for the record. We will conduct this meeting in usual fashion. We will first receive information from city staff about the application and the recommendation. If the recommendation is favorable and no one objects to the application, usually the Board of Zoning Appeals treats the matter as being uncontested and passes it as a matter of course. If, however, the city recommends against the application or there's opposition to the application, we treat the application as being contested and hear from the applicant and anyone else who is in favor of the application. Next, we hear from anyone opposed, followed by a short rebuttal from the applicant. We then close the public hearing portion of the meeting for that particular application and open discussion to the Board of Zoning Appeals members only. We will then make a decision to approve with conditions, or deny the application. Board of Zoning Appeals Site Design has the authority to do three things. 1, hear appeals to decisions of the zoning administrator. 2, grant special exceptions, fact-finding function of the board. And 3, grant variances to the zoning ordinance if the application meets the hardship test outlined in section 54.924 of the ordinance. The board may deliberate and make a final decision on a matter by a majority vote of members at the hearing and qualified to vote, provided that not less than a quorum are present and qualified to vote. For a variance to be granted, the Board of Zoning Appeals must make the following findings. A, there are extraordinary and exceptional conditions pertaining to the particular piece of property. B, these conditions do not generally apply to other property in the vicinity. C, because of these conditions, application of the ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. And D, the authorization of a variance will not be of substantial detriment to the adjacent property or the public good. The character of the district will not be harmed by the granting of the variance. Also, we have Paula Murphy and Kelvin Yuji that have joined the meeting for the board.
Thank you. I'll just go back to this slide. Meeting protocol, it's kind of where this is first back in person. So Joel, as chair, I think you pretty much explained it, but the chair announces each application, staff then presents the application, the city's recommendation. Obviously, I'll control the slide presentation. Recommendation is favorable. Nobody objects. Usually the board treats it. Yeah. If there's an objection, applicant, anyone in favor will be sworn in and allowed to speak. Next opponents will be sworn in to speak, and then the board then closes the hearing. So moving on to agenda item A1, Joel.
A1, review of minutes deferred application previously advertised for zoning appeal site design agendas. So does anybody have any questions about the minutes, or is there a motion for approval?
So I failed to get these out to you earlier, but basically it's the long form with the vote, who made the motion, who made the second, and then we add the conditions. So
I make a motion we move to approve. I'll second.
So all in favor, just say aye in favor.
I in favor.
Aye in favor. Anybody opposed? It's approved. So we have full house. How about that? So our second item on the application is item B1 is High Tide Drive, TMS 35800000008. Application number is 220406B1. Request a variance from section 54.327 to allow the removal of 3 grand trees. Request a variance from section 54.330 to allow a reduced impervious construction setback near the base of 4 grand trees. And it's zoned PUD and C.
So this is the application. HLA is the applicant. High Tide Drive, I'll explain where that is, and the nature of the application request.
HLA as the applicants provided this letter as to how they feel hardship test for the removal of 3 grand trees requiring a variance. Our map, so this is the back, what is that, maybe 1/3 of a development that was built a number of years ago. It was back when you could do PUDs as a single use planned unit development. And of course, it was like an extension of an adjacent PUD known as Shivling Plantation. The infrastructure went in for, like I said, 2/3 of the project as well as the cul-de-sac. But the owner at the time reserved platting those lots that front on the marshes of the Ashley River and a few that abut a new neighborhood called Magnolia Bluff. So we're dealing with the trees in that area today. Here's the aerial. So you can see that the road was built, some infrastructure was extended into that area that's heavily treed now. So this is a number of years ago. Obviously, trees grow. A number of months ago, I walked the site with HLA and their consultants, and that was following having a certified arborist go out and re-verify the size and species and condition of the trees. I pretty much agreed with everything that the consultant found. There are a couple F trees that were in serious decline or storm damage beyond repair since a number of hurricanes have passed over this land. C grade trees and D grade trees.
The trees, again, in the cul-de-sac are there and they're performing quite well.
Great trees. They do have to meet some new stormwater requirements. So there's a small pond there today, which has to be expanded. And of course, we have the 100-foot the 100-foot shoreline buffer, which will be reserved in an HOA. So you can see how it's up on a bluff. And that 100-foot buffer is measured from the Ozark critical line.
The original layout, I believe, had 2 additional lots, but due to the trees growing and becoming grand and density,
they shuffled some lot lines around, and this is the plan that they're presenting tonight. So we're dealing with 3 of the D grade trees, those orange trees. I'll explain those in just a minute. There's the arborist kind of notes in the lower left. I'll explain that in a bit. So here's a blow up of that one section. So we have a 37-inch laurel oak. Obviously I was concerned about buildability on the lots. This tree was a grade D, and this is tree number 4. So it was hollow and had some decay in it. And I'll show some photos in a minute. A blow up of the lots that front on the shoreline buffer. And tree number 7, another laurel oak, grade D. It has some issues. And then, of course, tree number 27, red oak with a broken top and in decline. This is the tree number 4. So you can see there's a kind of a weird bend in the crown where the lateral shoots off to the left, and there's some signs of decay in that larger crotch up higher in the crown there. follow. This tree is the one, tree number 7. You can see all along the trunk that there's pockets of decay and issues, and then some, what I think is previous storm damage in the crown. You can see the thickness of the central leader, and then it kind of stops and a couple of water sprouts that have probably grown since. I think that's probably ego damage. And then tree number 27, the red oak, poor form. So they obviously met with the board of directors of the McMorrow Bluff Homeowners Association. We received this written comment. I sent that to you the other day. Gordon Morgan, and they fully support the variance request for the 3 D grade trees and the setbacks. Let me revisit the setbacks. So as you can see here, the trees with the crosshatch circle in the center at the pond, and what we are dealing with here is most likely a very small encroachment for maybe a tire runner. We'll look at driveways very closely, but there really shouldn't be much fill activity because the curb line's set. They're going to just be moving some water and sewer laterals, but so driveway, and then the pond to meet some new stormwater requirements. That will be in it like an island on a peninsula, but maybe a slight grade change. So 2 trees in the pond and then 2 on the lots. So with that said, staff is going to recommend approval for the removal of the 3 grand trees. 75% of the DBH inches equals 68 caliber inches of native canopy trees to be planted on the project area. Must use 4-foot chain link fences, tree protection barricades, have a certified arborist prune and treat the grand trees to remain, and must provide a tree mitigation plan for staff review and approval.
All right, thank you. The applicant is present. Would like to be heard. Have anything to add?
One thing I do want to add, those 2
State
trees.
your name and address.
And Nick Allport, HOA address is 59 Commodore Road, Hollywood, South Carolina. The 2 trees in the island, the impact to those, actually adding soil back underneath the canopy of the existing pond. So that impact is not going to be as bad as it's. Other than that, Eric's done a great job.
Is there anybody present that is opposed to this application? And we'll close the application to the public and open it to the board for discussion or comments or questions.
Eric, the 2 lot trees that are looking for reduced impervious construction,
Yes.
in the island there? Or were those driveway lots with driveways that you were concerned about?
Right. So obviously, they have done a lot study. They feel a house will be built back here. Obviously, a driveway can't go left, so it's going to have to come right. And, you know, without the house design and the exact position of the garage and what have you, they're thinking that there'd be a slight impact maybe to a driveway there. This one is more like a flag lot, if you will. The house is either going to be back or forward. You know, we said we weren't going to support any impacts to that. So that's their challenge. But again, just to get off the right of way with the driveway.
Are we still suggesting pervious driveways in those
Oh, yeah.
scenarios?
Absolutely. Yeah. Absolutely. That's a very good point. I was thinking that as a condition to look at tire runners, pervious pavers, even sand shell, you know. Have to be a small apron probably at the interface with the right of way, but then we can do a very light on the land driveway.
So that says lot 19. So is there a like a maximum encroachment into that tree canopy we should approve?
So it's the tree protection zone. So the tree protection zone, the impact symbol is much smaller. It's the outer ring is the tree, what we call the TBZ, the tree protection zone is based on the diameter. So that's just a symbol to identify that tree as one that will have a slight, that's,
Right, So I guess what I'm getting is the term slight
Right,
is used today,
right.
and then slight becomes, 10-foot encroachment into the tree protection zone or, do we put, 20% maximum encroachment?
I see where you're going.
Is there a standard with an arborist that would say, hey, you could go up to 30% into that with some runners, it's not gonna hurt it, or
Let's maybe consider adding a condition that for those lots, a certified arborist and I have to meet with the layout on the lot and come up with a plan that satisfy the city.
If they did put in the cart strips, you called them what, tire runners?
Yeah, I call them
Yeah,
tire
yeah. I mean, those don't have to be particularly, those are pretty small impact.
Right, that can be, I don't know what the homeowners are going to be driving, but with the curve and all, you have to consider, you don't want to have, mud if it's grass between the tire runners or whatever, but we can work on this.
Gravel.
Yeah.
Right, but you can make a larger area of gravel that you're still gonna be excavating a little bit to put the gravel down, or you can just put in your tire runners. But they'll pay,
well, I think Eric's comment of
yes.
arborist with applicant in city kind of addresses, it takes care of that. So if we just add that to motion might be made. Don't have any, because I think the trees will,
Well, the HOA sent the approval, so I agree with you. So I'll make a motion, we move to approve with staff recommendations, adding that the driveways and the impervious construction setback zones need to be pervious, and that the applicant needs to meet with city staff on site and the certified arborist to look at those.
just on the plan. I mean,
On the plan, yes.
the onsite.
Second.
Favor say aye. Aye. Is there anybody opposed?
Can you read that comment back? Sorry.
I didn't write it down. Did you, Eric?
So I got, this is the gist, to add condition number 5 that would read, the applicant is to present to the city with an on-site meeting the layout of the driveway as it passes the tree protection zone, and that the material within the tree protection zone needs to be pervious.
And you have in there with
Certified
a.
arborist.
Certified arborist, yes. The applicant, certified arborist in the city on site with the driveway staked out. And the material within the TBZ needs to be some form of pervious material.
Fantastic, I'll add
Is there anybody that was opposed?
Rusty.
Yeah, so that's approved 7-0. Y'all, thank you for your time. All right, so we will move on to our, oh, you're gonna let these people in, right?
Yeah, we're trying to, well, I don't draw big crowds, but if we had big crowds, we'd have. 539 Harborview, are you with CWS? Let's jump out of order. Maybe somebody with CWS is stuck in traffic.
Item B3.
Yes.
Mid-Bank Highway.
B3.
Your lucky day. Up on the list. All right, so we're gonna move to item B3, which is Maybank Highway. The TMS numbers are 313-0000-306, 307, and 031. Application number is 2204-06 B3. Requested variance from section 54-327 to allow the removal of one grand tree zoned PUD.
Very good. So this is the application.
The owner being Mark Goldberg, the applicant again, HLA. This is their response to the hardship test for the one tree requiring a variance. This site is presently an assemblage of 3 lots, actually greater than 3 lots. The PUD boundary isn't quite shown here, but it will be in the next slide. But the tree is specific to phase 1, which involves these 3 lots. There's the PUD boundary. There are a couple parcels to the west that are incorporated. It is truly a mixed use. There's going to be office, retail. There's actually a boat, RV storage facility. And then we're hearing rumors of a brewery being relocated to this site. But phase 1 involved the public roads. Again, very important to the city to get that road that's at the back of the site in front of that large pond. The Johns Island Community Plan, as well as the recently adopted city comp plan, calls for an alternative grid planned over Johns Island within the urban growth boundary. So anytime a project comes forth, we look at where the future connections east-west could occur. And this seems to be the most logical location. And then again, you see how the road aligns across from Walter Drive, Walter Road, and then it does a little S-curve. And then it's being planned to have that intersection along that large lake planned north. That would be a private drive to a new facility built back there.
So we got through the concept plan without the need to go for a variance for trees. SCDOT worked with the applicant. They were thinking the 2 live oaks plan north on the right would be impacted, but we got the decel lane reduced, which was a very favorable thing. The other trees on the edge of the road, I felt there, and one thing I have to point out is there's a major drainage canal that goes down the center, which is going to be relocated and filled to make this land more conducive to retail, office, whatever. But so anyway, as it went through preliminary plat, went through road construction, and as I was conducting the tree barricade inspection, I came across a live oak that I'll explain, and it's that one that's in the road. And
There's a blow up of it. So this is a letter the applicant will have to speak to as to the date of when the arborist did the initial confirmation of tree size and species, but at the time they had it at 23.5 inches. When I went out, the way I looked at the tree, and we'll talk about the point that you would typically measure at 4.5 feet above grade, I came up with 25.5. And I don't think a live oak over the time that I heard the original inventory was taken would grow that quickly. So I ruled that it was a grand tree, and we met out there. So that's the measurement of so they're calling it a 24.5 as they would measure it, but they do talk about where you measure. And so this tree, just about at 4.5 feet, does have some abnormal, bark formation, and you can see where the tree's starting to split into triple codom tree. So in the industry, there is some standards as how you would drop down, below that abnormal connection point. So I think if you drop all the way down and measure just above that brown leaf, you would probably get 24.5. I measured a little higher where I felt was fair and got 25.5.
So then the tree itself has some really interesting included bark, and there's a break and a hole in the crown on on the right photo, some storm damage. You can see some cracking that they almost look and feel like cracks between where the included bark is as those stems put on more girth. So there's a break, there's a limb that's laying that broke out of the crown there. So they say B. I was on the fence BC with my grade because of the bark inclusion and what have you. So with that said, with the road, I looked at whether the tree would be worthy of trying to split that road and do an island, but because it would then be maybe on an HOA island, but within a public right of way, I had some concerns. It's pretty designed. They went through a very rigorous stormwater design, relocating the canal there that went down the middle. So I'm going to be supportive of the removal with the following conditions: that 25.5, that's 100% of the DBH inches. Native canopy trees be planted on the project site in addition to the previously approved landscape plan, which is basically street trees for the public road. They could modify and enhance the buffer along Maybank and what have you, and then provide a revised landscape plan for staff review and approval. In the interim, what I did is they barricaded the tree. I did not include that photo. And we released based on the approved road construction documents, the land clearing operation to proceed. But they were at risk.
Thank you. The applicant is present. Is there something you'd like to add or share? If you would state your name and address for the record. If you want to speak.
Not really, I'm just, Eric mentioned something.
David.
At Stafford, I'm with HLA, my address is 3202 Middlebury Lane, Charleston. I'm just waiting for information from my office with regards to the original survey, if that's still required.
You don't need the original survey since we've got just moving forward with. Okay, all right. Does anybody else want to be heard in favor of the application? Is there anybody present that's opposed to the application? The application to the public and open it to the board for discussion.
I feel like the grade was very generous. My first reaction was that I would grade it a B- or a C. And then when you put it that close to a road or to a building, that's a lot of risk to persons and property. And so that's something that really needs to be taken into. I think the staff recommendation is right on.
Anybody else have a comment or question? Is there a motion made?
Approve with staff recommendations.
So motion to approve with staff conditions. All in favor, say aye.
Aye.
Aye. Anybody opposed? It's approved 7-0.
Made the motion.
Bruce,
Yeah, and it was seconded by
Jeff. So Jared Hartwig. Thanks.
We good?
Yep.
yes, approved. Thank you.
You guys don't like to hear things without the applicant present, but it's a pretty straightforward request, but it's up to you all.
Guess that's what the applicant thought too. They can't figure that one out.
CWS.
Or CWS.
It's allow a reduced OCR critical line buffer. So we listen to it. Got time, we're here.
Plum Island.
Concerns of the main piece of infrastructure.
It's pretty important to all of us.
Yeah.
All right. The final item on, well, no, the next item on our agenda today is item B2. We're going back to that, and it is 539 Harbor View Circle, the TMS number 424000007. Application number 220406B2. Request a variance from section 54.347.1 to allow a reduced OCRM critical line buffer, zone C.
Okay. So this is the applicant submitted by Hazen and Sawyer, specifically by Jared Hartley, consultant for CWS. This is the large tract of land, obviously the islands in the middle and zone conservation. Therefore, conservation requires a 25-foot landscape buffer against the OCRM critical line. So this is the aerial view of existing conditions. And just take note of the upper right portion of the island. It's aging infrastructure that needs to be upgraded to handle the area's growth, as well as just upgrading equipment. So that's the parcel as it sits. And existing conditions. Again, just kind of keep your eye on the upper right portion of the site, right side. So this is the demolition, overall demolition. Everything in the grayed out area will be demolished, as well as some surface material near the round tanks. And then they build new affluent pump station, and I'll blow up the, so they're hemmed in by limited space, obviously, with other existing structures and infrastructure. So this is the affluent pump station, where you can see whatever that portion of the building or structure is that protrudes out the right, crosses the buffer line slightly. They're showing a squiggly line of some vegetation being left on the edge, but so that's that. And then the final settling tanks, solids handling building will all be new and odor control. And then on the north side of the island, just a small little piece of something that is associated with the disinfection facility encroaches over that line just ever so slightly. This is the overall landscape plan, which, you know, they're saying that they'll enhance that edge with wax myrtles, native grasses, yupon holly, whatever. Work with them on that. So staff recommends approval with a landscape plan indicating native shrubs to be planted in the 2 zones of the proposed encroachments for review and approval.
Mr. President.
I might add that we treat this, this Plum Island has been before this board in the past. And in lieu of doing a special exception to, that's a pretty rigorous process to, you know, demonstrate that the receiving water body would not be adversely impacted if the buffer was adhered to, but because of the nature of the use of the island and what they're doing there, it will go through stormwater review. And so we just treat it as a variance versus a special exception.
Good. Is there anybody present that is opposed to the application? The application to the public, I'll open it to the board. For comment, I guess.
What's the reduction?
I'm sorry, I didn't get that dimension. Based on this 25-foot, it looks like maybe 7 to 10 foot. For that, it's angled. The OCRM critical line kind of, you know, angles and jogs. And then on the northern portion, that small little box, whatever it is associated with the disinfection, looks like maybe 3 to 5 feet. But I'm sure there's some grading that has to occur. So I apologize for not having that exact figure for you.
Go forward.
I'm all for upgrading. Get more odor control.
Is there a motion? Application. To approve. And Ruthie was the second, so all in favor say aye. Aye. Approve 7-0.
All right. very good.
Thank
So
you.
We will skip to B4 quickly. And introduce our wonderful legal head of our legal department.
That's lucky you. Thought you were gonna have a short meeting, but now you're stuck with me.
Yes.
Unless
Julia Copeland.
tornado sirens go off.
I know, I saw that. I asked Lee, are you gonna cancel the meeting? We have a tornado warning.
No, not a warning.
Oh, is it a watch?
Watch.
It was a warning till 11.
It was a warning last night.
Yeah, 'cause
Not a watch, yeah.
I think the warnings made me much more nervous than the actual weather itself. but-
I'm going to skip out and go get parking.
I know you by your face.
Yeah, I got
Julia Copeland.
Tell me your name again. Jen.
Hey, hi, everybody. I'm Julia Copeland. I'm part of the legal team. You're the newest member, are you?
Yes,
Okay, welcome.
thank you.
Welcome to the team. It's actually fun to watch you all work together because you actually work really nicely together. I've seen some terrible boards and commissions where it's almost literally painful to watch and sit through. So it was refreshing to see you all collaborate and talk and get to the motion and all of that. I'll credit the chair with that because we ran a tight meeting. So I will make this as brief as possible because you have a handout. It's pretty self-explanatory. You can read it on your own. If you have any questions, I'll give you my email afterward. Always happy to chat with you privately if you have any questions after this. So as you all know, for state law, you as a board or quasi-judicial board, and you have 3 defined duties of authority, and that is 1, to hear appeals of your lovely zoning administrator here, which is always fun because you get to sit as a court and consider evidence de novo, as if the decision had never been made, and choose to overrule him or uphold his decision, or even alter it, which is always interesting. But lately, I feel like you have been a little bit all over the map of this. I think you've upheld Lee Batchelder at some point. You've actually reversed Lee Batchelder at some point on that variance on the.
Remember those.
I know, if you keep a track record of so many years. You also are hearing variance requests, which I just watched you go through today, which are 3 actually, which you've all handled beautifully. And then, of course, to consider special exceptions. Oh, and finally 4, which is an added benefit. If you grant any kind of variance or any kind of special exception, you get to hear any requests for an extension of that specific vested right. So we'll cover that in a second. But let's go ahead and talk briefly about special exceptions, which I find pretty fascinating. You're basically on a fact-finding mission of these. I have a feeling you get a varying number of special exception requests, so this is not your first rodeo, right? But yes, you could take testimony, hear testimony, and ultimately decide whether or not the testimony conflicts with the special exception of the use that they're asking for. My main concern for you all as a board, just because what we get to handle is the litigation or appeals that follow after a board decision is made, either in favor of the request or denying the request, is that you build an adequate and full record for us, so that if you are choosing to deny something, you are stating on the record and in the order your basis. So I can take that to court and say, look, they had a rational basis to do this. So yes, and I do feel like you're doing that now, at least from what the records that I have been reading today. And Lee, I'm sure, runs a very tight ship around here too.
Very.
Still being recorded.
Yes.
Oh, great. Should I take it back, anything I've said so far today?
I won't ask the question when you were saying.
And then we had a rational thought for the approval or the denial, saying the check hasn't cleared yet, probably not a good.
Probably.
Not a good job. Not a good job.
Best thing to state on the record. Oh, hello there. I know, right? Are we giving out candy or good? Okay.
passes.
Yes.
So again, special exceptions are pretty cut and dry.
Thank you.
Variances, of course, you've got your 4-part test. I did get to see a situation today where you're going to the 4-part test.
I would love to see to remove the 4-part test of all the applications. And that's something that I've kind of brought up to you guys before, if that's something we can see ahead of time.
Via email. I don't know that we got it
We
this
didn't
time,
get it this time.
but we've been getting it via email and you can go through and read it. That way he's not having to read through everything in the meeting.
So we'll get those going forward now that we're back in person too. Okay.
They do that in North Charleston as an example, depending on what community. So North Charleston goes through every application and goes through every step of what is it that you're supposed to be doing.
They do it in Mount Pleasant too.
Yeah, they do.
Mike will read every single line and go through every
Yeah.
single point. And that makes your meetings a lot longer, but it's really the prerogative of the zoning administrator and the board, if that's something that you want to see or hear going forward.
As long as we're getting them out of time still. That's-
I think that has made a huge difference, getting everything in advance.
Good to know. I like this. You're a hot bench. You have to sit and stare at me while I talk. It's always good to have a bit, that's for sure. Okay, just remember with vested rights, let's talk about vested rights for a minute, because this always comes up and we litigate it all the time. You get 2 years, all right, on your vested right. And if you don't do anything with it, you're done. If you're at the very cusp of the end of your 2nd year, you've got to request an extension. And it may not be automatic because sometimes our council changes rules, changes law, and what you could have built 2 years ago, suddenly the ordinance is not going to make it possible. So 9 times out of 10, that they come to you for an extension for a year, which they get 5 opportunities to come to you for a 1-year extension. 9 times out of 10, it's automatic because nothing has changed, but there's always one little creepy case that 1% that there is a problem. And if you see me sitting in the audience wanting to go back into executive session with you, that's probably going to be that particular case. But 9 times out of 10, the law underlying the original decision has not changed and the extension granting would be automatic. All right, let's see what else have I got. All right, you already know about your training requirements. Jennifer, do you know this yet? Lucky you. Under 629-1300, you all need to have a certain number. Is it 6 hours your first year and then 3?
6 hours the first year and then 3 after.
Okay, so just make sure you all keep that in track. And of course, you can be exempted from that if you are licensed or certified under certain varying degrees of practice. You can actually be exempt from the training requirements, and they are listed here on page 11. You might actually fall into that, so take a look and make sure.
Thank you.
All right, let's talk about ethics. Have any of you ever had to pull out with a conflict of interest and recuse yourself during a board meeting? Okay, you must be in real estate.
Yes.
Okay. Yes. If you or a family member has an opportunity to make a specific economic interest in a certain decision, I can't tell you to recuse yourself, but if you come to me and ask, what do you think? I would tell you, yeah, you probably should. And in that situation, you would send a written, do you have a form?
Yeah.
Okay. And you fill out the little form, you hand it to Lee, and then we put it on the record before the meeting starts. And if you ever have any question about whether or not you might have a potential conflict on any application, please feel free to reach out to me. I'm happy to chat through it with you. Varying board members and council members, so I'm always happy to help. But just know that if you do recuse yourself, some boards are different. I'm not sure how Lee handles this, but some people have to leave the room. If you recuse yourself, you walk out, you don't sit here. Certainly don't participate in any conversation.
That is in our rules, because that's the way we've always done it. And when we wrote the rules, we just wrote what we were
Okay.
doing.
I have something on that note. I'm self-employed and I work by myself. So when I have something, I don't often have something that needs to come to the board, but I have to be out of the room and therefore I cannot be presenting the project. And that's how they've always handled it.
So what do you actually do for a living?
I'm a landscape architect.
Okay, so your actual project is
Could
up
be,
for consideration.
yes.
So what do you do in that situation?
I have to leave the room.
Do you have anyone presenting for you?
Well, I mean, the owner could be, but they're not gonna necessarily you know, be able to answer the questions.
Yeah, see, that's tricky because. my
Or
first
arborists, I
review
mean,
of the
they're-
board- Yeah, I mean, it makes sense that you would have to go because that's,
Can this, I mean, you can put something in an application
Right,
that explains
Right.
your points, why you think. you-
right, but it's different. You're not here to answer the questions.
right.
Yeah.
Some people might say that's influencing the decision, which is also covered in the act. So it's always best to, if you're doing the right thing, it doesn't feel good, I can imagine. But there are ways to cover that before the meeting actually starts, like Lee's suggesting. We're always happy to help you with that. How often does that happen for you?
Not very, because I try to avoid that. And I tend not to work on, you know, big stuff. So
How many years have you been on the board?
Well, her sign indicates that she's been here because these are metal. This is aluminum. And when I went, I had to dig these out. And my gosh, we had to quick scramble to make paper of it. So she's been here for a long
probably 10 years, you think?
time, close to 10.
I'm close to 10, if not 10.
Yeah, so
I came
probably
on at the same time, I think, as
3 or
Joel.
4 terms, I guess.
Wow. Thank you for your service.
Well, nobody else will do it.
I know. It's really public service, it really is true. It's hard
Well,
to get good people.
It is unique in Amanda's, because if we approach a landscape architect that lives in the city or has their company in the city, they would always be in conflict because most of those firms bring stuff to us, so
Yeah.
it's tricky.
A little easier when your firm is doing it though. She can leave the room, but there's gonna be someone
Right,
involved
right,
that
right,
asks
right.
questions. So, yeah, that's tricky.
I do it for me.
Yeah.
Well, Joel's in the same situation. And
Do it for the pay.
Jennifer. Right, you work by yourself, right?
Well, actually, I just started leading the design team for Carolina Landscape, so.
Oh,
Congratulations. Thank you. Okay, well, let's, I'm sure why Chip had dual office hold. But most of you know, state law can't hold 2 positions, honors or pay at the same time. And I do not believe that, do we consider the BZA a position of honor?
That's what the Attorney General says.
Well, who knew?
We had that issue with former chair of this board, who spoke to Councilmember Seekings about his complaints with CARTA and was promptly appointed to the CARTA board. So he had to resign from the BZA.
Yeah, and it's automatic. It's considered automatic under state law, so.
Yes.
Yeah, this comes up on occasion sometimes, because there's people that want to be in public service and they get dragged into everything. So, okay. But yes, this is a position of honor. Who knew? There are some boards and commissions that the enabling legislation drafted by the legislature specifically says, by the way, this is not a position of honor. And I'm thinking, gosh, who would rush to do that? I mean,
Not good for
goodness.
recruiting.
All right, I think you probably already all know this, but since you are a quasi-judicial body and you are a board of the city, we do not encourage ex parte communication with any applicants. A lot of applicants complain about that because they want to at least see what the feeling in the room might be, but I have to tell them constantly, sorry, you know, I just can't do that. So we do not encourage that. Let me talk to you about FOIA real quick too. I know FOIA is not in the packet that you guys are holding. Let's talk about the Freedom of Information Act. So because you're a public body, you're required to give public notice if you're in a meeting. Okay, a meeting is a quorum of your body. So that's 4 or more. So we highly encourage you all not to have any meetings offsite, no group text messages, group emails. There's still no case law on that, but we encourage you not to get in a debate amongst yourselves with group emails, because that would be considered a meeting of the body without public notice. We also tell council members, you know, try not to meet at a bar after the council meeting, you know, and 5 or more, because I know you're all just having a beer and chatting, but it could give the appearance of impropriety, which we always discourage. We encourage you not to do site visits with 4 or more. If you're gonna go do that, with the BAR, they always want to go see the site together. We have to say no, just go in separate times and separate groups. Going to a planning commission meeting, if you're all gonna go, don't sit together in a group. Just to avoid that appearance that you are in a public setting as a group. without notice of a public meeting to the public, the general public.
So no barbecue.
I've had the BAR do that though.
There are times I can't control adults, unfortunately. I mean, if I had a shock collar, sometimes I think I would use it. But yeah, this is the same information or the same request that we put to everybody. And sometimes you just, there was a particular appeal coming up on the agenda, and they wanted to go look at the site together so they could talk about it. And we told them no. But if they decided they wanted to do that, we would have to put notice to the public that they're going to be at this address at 3 o'clock in the afternoon. Because, you know, that's, with FOIA, it's dangerous because any citizen can file a FOIA complaint. And if they're 1 point on the winning side, they get their attorney's fees and costs. And 9 times out of 10, people who file FOIA complaints are usually pro se. They don't have a lawyer advocating for them, so the fees and costs are relatively low. But every once in a while, you get a Tommy Goldstein who will jack up the price, and you know, it's a nightmare. So just keep those things in mind. I'm sure you guys do anyway. You all know, have you gone into executive session in your 10 years? Okay, okay.
We did recently.
That was a pretty fun phone call. Everybody was trying to figure out how to get on the call.
Oh, this is the one with Hayward. You
That's
remember?
correct. Yes, that's
Yeah.
correct.
He texted me like, oh my God, I'm going into executive session, what do I do?
What was that even? I don't even remember what it
I
was.
just remembered all the
That
technical.
was the Central Park case.
Oh, yeah.
Tree, or was that raising the houses?
Trees.
And precedent creates a lot of consternation. We have 4 lawsuits right now, all from Crescent. But that's neither here nor there. That's over a drink, guys.
That's right.
Okay,
But no.
but not all together. I would have to drink with each of you individually.
Were you trying to trick us?
Exactly. Okay, but you all realize that so for executive sessions, you can go into executive session out of the eye of the public to receive legal advice. Just always make sure you state on the record why you're going into executive session to receive advice on this particular issue or topic. Don't just say we're going into executive session to get legal advice, because that, for our state Supreme Court law, is a violation of FOIA. And people will file lawsuits over nonsense like that. It happens all the time. And when you come out, make sure you state on the record, we took no action, took no vote. Yeah. But I'm sure Lee and Eric will stay on you on that one.
Did you say you always have a motion in second?
To come out?
To go into executive?
Correct. Yes. And then a motion and a second to come out of executive session. You come out here, do that, make your statement, and then go back on the record with discussion of the particular topic. Let's see, what else have I got here? I told you it was gonna be quick. Just hopefully it's not too quick. Oh, Public Records Act, your emails, your text messages, anything city related is subject to FOIA. So, case in point, there is an active lawsuit right now going on in the town of Mount Pleasant. And when Ross Appel put in the complaint 10 pages worth of text messages and emails amongst the DRB members talking about how can we kill this project.
Oh.
Okay, bad, very bad. Always remember, when you are emailing each other or texting each other, you could be subject to public view and perception, especially in a situation like this. So always keep that in mind. Always save any pertinent emails about a specific project, because I know it's all going to your personal or work emails, because we don't have city emails for the boards and commissions. Keep it in a folder. Just save it over there if it's pertinent. Not like, is the meeting at 5, is the meeting at 3? Those can be deleted. But the ones that you're talking about, serious issues with the project, if you are doing that, make sure you save it so that I can call you and say, hey, I got a FOIA request for all your communications regarding the poop plant in James Island, and you could just pull them and send them right to me. That's my biggest piece of advice for you. Even on your personal cell phones, if it's city related, email it to your address and put it in the folder. As I've had situations in Mount Pleasant where I had to hire an IT guy to take your cell phone and pull your email or pull your text messages regarding a project. And that is not fun. So always keep that in mind when you're communicating with each other. I always do that. I love to hear that.
They do it without me.
Yeah, me.
Wouldn't be the first time in my
You're
life.
not invited to the barbecue. It's just not, okay?
Call that a no Joel meeting.
No, I can't think of this, I can't think of that ever
Can't tell
happening.
Joel.
Good. I I always tell people, just pick up the phone, just call. Just go back to the old 60s and 70s way of things.
Only thing I'd ever get text wise was when we were doing Zoom calls and Andrew was on the board. Joel, speed this up. Phone over, anyway, what?
That's right.
But that's all I have for you. I told you it'd be short and sweet. If you have any questions for me tonight, please let me know. And otherwise, I will give you my email address. It is copelandj@charleston-sc.gov.
I had an attorney last week, we had court reporter minutes, and I said, no, we just have, somebody takes the minutes. Has that ever come up?
Always.
And
So we're recording these meetings, correct? So if you guys we're recording them, we're posting them on YouTube, so they're available that way, correct? Because generally what happens is if there's an appeal, the first thing they ask for is a transcript of the record. So we have to pull the recording and have a court reporter transcribe it. It would be nice if the city had someone designated to sit here.
We did prior to.
Well, the clerk.
Yeah.
I mean, somebody from the clerk.
Just started a recording, yeah.
They don't have the staff.
Yeah, I mean, I'll have to talk to Jennifer about that, but really, especially with the BZAs, because those are the ones that generate information, because you're a quasi-judicial body, to have it recorded and transcribed, even by a third party. Might be by the court reporter service to do that. But right now, we're saved by the fact that our meetings are.
That's
Yes,
gonna continue.
yeah, thank goodness. Because otherwise.
But our audio system in here is not the same as doing a computer Zoom meeting. So
It's hard to hear.
it's a work in progress a bit.
So maybe that is something we should talk about later. Anything else? Oh, you're very welcome. You're very welcome. And Jennifer, if you have any follow-up questions, since you are the newbie, I'm happy to help.
Thank you so much.
So with the, I know that, as I only have a 5-year BLA, not a master's, I don't qualify for
Exemption.
the exemption. But I do know that,
But you're licensed and registered, aren't you?
oh yeah, of course.
Yeah, so does that count? No?
No, I still have to, but we can use APA, and Jennifer, I'm sort of directing this to you, you might have masters, so maybe it doesn't matter, but if I take an ASLA course that's also certified by APA, that can count towards this.
Oh, good. So you can kill 2 birds with 1 stone. Nice. I
Yes.
love that.
So that's just a good to know
Can I
thing.
count this as part of my real estate CE?
I don't know. That question has come up before, and I don't know who we would reach out to find out.
It's okay, I love to.
If that's okay, I mean, if that's the case, I'll just keep talking for another hour.
Yeah, there you go.
I know. Tornado be damned.
I was thinking the same thing.
So, yeah. Now, Mr. Hughes, you're the lawyer in the group?
Unfortunately.
How much more time do you have left on your term?
A couple years.
Oh, you're relatively new too.
We filled the unexpired term of Emmanuel Ferguson,
Uh-huh.
and I don't remember how much time was left, but I think he had just been reappointed, so you might probably be up for reappointment next year.
It's tough to be a lawyer all day and then come do this. Well, I would say that for everyone, every profession. So we certainly appreciate everything that you guys do. Okay, thank you, everybody. I hope you all have a great night.
So,
Stay safe.
one more thing. So you have these parking passes.
Yes.
And what you do is when you pull up to the gate to exit, you'll take the parking ticket that you received when you came into the garage, insert that into the machine, and then you'll insert the voucher into the machine. And the voucher should then enable you to exit, no problem. If there's a problem, then there's a black button on the machine, and you can push that and talk to somebody and tell them, you were in this board meeting and you just inserted your voucher. You it out and it's not working, and they should be able to take care of it. So if there's any problem, let us know.
So
And
7 hours for our off the record meeting at the bar after this, or?
Well, no, you can pay the garage and then use this
It
again.
says 7 hours for free.
Yeah.
Mine says it doesn't expire until July 20th.
That's right. That's
I've been in
right.
my car
So
for
you
a
can,
couple
you can
months
save
there.
it, you can save it and go to a Spalito, save it and go to a Spalito event.
This is a fun BZA. What's the other one like?
They're not fun.
It's like VA or large and small.